here and yeah, but it doesn't mean you can't tell students every third semester. Every semester. I'm sorry, year. Third semester. Well, it makes no difference. I don't care, but when I looked at your schedule, Jude's schedule, it looked pretty awful to me. If you guys don't want to do anything, it's modern, and in your case, great.
Yes, it's not my business course. I could do if I have to do it, I think a year. Definitely somehow so that
But you want to do benefits, why should
yeah, so then hey, you yes,
He did.
okay.
And I have the top.
Okay, great.
So,
Okay, great.
you go first, go?
I want
That's part of it, I'm sure. Also, people are, this is sort of the latter part of the semester. So for this time. Well, I guess I don't see the reason to wait any longer. Thanks for coming. Welcome you to a continuation of our series of talks on professional ethics. Today we're going to hear from Jan Narveson. He is Distinguished Professor Emeritus at the University of Waterloo. He authors 7 published books. 2 of them are The Libertarian Idea and You and the State. He is a fellow of the Royal Society of Canada, and he was made an officer of the Order of Canada, which is that country's highest recognition of civilian achievement. It's over to Professor Narveson to speak on intellectual property.
I'm glad that the last time I'll be introduced today. Okay, this talk is going to dispense with that on the fourth day. This talk isn't perhaps quite what you saw on the sign, though it's not, as they say, not unrelated. In fact, it's about intellectual property rights. This is a hot topic in 2 ways. I mean, number one, of course, on the current economic, business, etc. scene, intellectual property rights are just extremely important. All the quarrels about pirating CDs, for example, and music are in that arena. Most of the high-tech companies are extremely jealous of the various intellectual property rights they claim, etc. But there is a problem about intellectual property rights, which has been pressed at some length by a chap named Stefan Kinsella, who in fact was a patent lawyer, or maybe he still is, but anyway, he was for many years, and who knows a great deal about what he's talking about. And he wrote a very interesting book, which, by the way, is freely available online, claiming that there is no such thing as intellectual property rights, which would be serious, serious news to a lot of people on the scene today. So my discussion is certainly stimulated by Stefan's book, but it's an interesting subject in its own right, as are property rights. And what I propose to do today is firstly talk about property rights in general, to see where intellectual property rights in particular fit in, if they do at all. So we're going to start at what I think might reasonably be regarded as the beginning, which is to talk about what property rights are. All right, now the main thing that property rights are and what causes all the fuss, e.g. making people like Proudhon say in the title of his book, Property is Theft, okay? What they mainly are is exclusions. If you own something, it means everybody else is excluded from its use. That is to say, more precisely, the people who don't own it have to clear it with the people who do. And that's the idea of ownership. You've got to ask me if it's mine, you have to ask me whether you can use it or not. Of course, my use of it is also limited by other people's rights. You can't use what you have a right to use freely to the point of violating other people's rights with it, and so things get complicated. Nevertheless, that's the very general idea. Now, we have to make a couple of distinctions here, quite necessary for paving the way to the discussion of our topic. First, we have to distinguish between property and what I will call possession. I'm not the first person to call it that. Rousseau, for example, was. Property versus possession. Now, the difference is this. Property is literally a normative concept. Now, whether it's moral or legal is the next topic we'll discuss, but the point is it's normative in the sense that when you say that somebody owns something, they're saying that he ought to be or has a right to be protected in the respects in question, whether or not he actually successfully has been so protected. Possession, on the other hand, is descriptive. The idea of possession is you've got it in your grasp or in your control. Whether legitimately or illegitimately is beside the point when it comes to applying the word possession, okay? So the point is not to confuse them. That is, possession and property are not the same thing. You can have either without the other. You can possess without owning, and you can own without actually possessing. All right, next we should distinguish moral and legal. We don't have to, go at great length into this, but we do have to note that legal discussions of property rights are usually discussions within the context of an existing body of law. And when they are, legal rights are in a sense determinative. That is, they're determined by the body of statutes and so forth that actually exist, and you've got a legal system, judges and whatnot to interpret this, and the point is the answers that are supposed to be on the books there somewhere. Moral is different. When you talk about moral talk, you're talking about what people in general ought to be doing. So what principles should be covering everybody's behavior. We, for this purpose, won't go into things like whether moral relativism applies and whether everybody is everybody or just everybody in a certain area or in the knitting society or whatever. The point is only that morality, unlike legality, is informal. That is, morals isn't written down. When people like moral philosophers, or Moses for that matter, try to write them down, what they're writing down is their shot at it, their opinion about it, but nobody is able to write it down in this sort of definitive sense. Whereas when the legislature says, okay, this thing has passed our procedures, it is now law, what they say is definitive in the sense that, yes, now it is law. That's the general idea anyway. Footnote, of course, some people talk about natural law, or they talk about the underlying principles of law, and when they do that, they are moving toward collapsing the distinction of legal and moral, and for our purposes, that doesn't matter very much. Okay, question then, how do we come by these things if we do? You have to say if we do, because there is always the logical possibility of denying that there are any such things as property rights, or for that matter, any rights at all. In this paper, we're not going to say much in defense of the existence of rights, but I am going to say a little. And that's partly because I think that property rights and rights generally are very, very closely related. Well, now on what we might call the classic theory, and I guess the classic theory is due to Robert Nozick nowadays, who in turn got it more or less from Locke, who probably got it from Roman lawyers 2,000 years earlier, etc. There are two there's a division we can make between two general ways of acquiring property rights. One is by exchange or transfer, and the other is what's called original acquisition. Now, exchange or transfer is, in a sense, the easy way. What's easy about it is this. Suppose that Jones already owns X and Smith already owns Y. Suppose that Smith would rather have X than Y, and Jones would rather have Y than X. Well, they're in a position to make a deal. I transfer my ownership of Y to you in return for your transferring your ownership of X to me, and terrific. As I say, that's easy. What's easy about it is the participants to this exchange were already right holders. They are already presumed to have owned whatever it is they're exchanging. Footnote, they might not, they might only possess them. A complication that is irrelevant for present purposes, we can ignore it. But the point is, in the sort of standard case, the normative outcome is easy because it gets it from the inputs. You had the rights before, he had the rights before. We both had rights to do notionally, more or less, whatever we please with these goods. One of the options is to give them to somebody else, and I do it on condition he gives to me, and he says yes, and we're in biz. So acquiring property rights by exchange is, roughly speaking, easy in the conceptual sense. Original acquisition is, of course, another matter, and that's what a lot of the ink is still about. I mean, a huge amount of ink is indeed still about this. Now, original acquisition means that prior to your acquiring the thing in question, it was not previously owned by anybody. And that distinguishes it from transfer, where it was previously owned by the other guy, the other partner to the exchange. Where there is no other partner, and you come to own it anyway, if this is possible, then that's why it's called original acquisition. And here we can distinguish, rather importantly for purposes of our ensuing discussion, finding the thing and making the thing. Now, the idea about finding the thing is there it already was, and you, so to speak, stumbled across it. Mind you, you might not have stumbled. You might be a geologist, extremely highly trained in the knowledge of where to look for the thing in question, mineral veins or whatever. And it could be that you found it as the result of a lot of extremely intensive and maybe expensive intellectual and other kinds of labor. Nevertheless, there it was, and you came upon it. Or we can take a sort of simpler case in the state of nature, as we call it. I mean, lots of discussions of these matters take place in that mythical condition. What's mythical about it? Well, whether it's mythical is part of the debate, really. But the idea is, okay, prior to some time or other, at least the time when there were no people around, or when the first people were around, there must have been things that were not owned by anybody. And the first people who came along would be in a position to literally find the things that were lying around, especially like pieces of the earth. Question. Does funding actually give rise to property rights? Now, as I say, that's a normative question. So what it means is, should we regard the fact of being the first person to, let's say, possess something, should we recognize that as a good ground for regarding you as owning the thing in question? Now, the classic Lockean answer to this is also yes. And as I say, that's what there's been a huge amount of discussion about. Why is there a lot of discussion about this? Well, it's especially because of exclusion. When you own something, as I say, you exclude everybody else. Well, look, I mean, here's this thing lying around in the state of nature, and anybody, we will suppose, could have found it, and it just happens that you got there first. Why should we give you actual ownership of the thing in question? Why should we recognize and defend your possession of the thing rather than anybody else's, or maybe everybody else's? Now, there's a lot of water under this bridge and a lot of neighboring bridges on this particular topic. I want to mention among relevant waters here, John Locke's idea, which he lets slip, I think, without really having thought too much about it, that nature, natural stuff out there, is somehow the common property of mankind. That's a view which in one language or another is sure to be familiar to everybody here. It is, for example, very characteristic of people today to suppose that when, for example, a whole bunch of oil is discovered in a certain area, then it in some sense belongs to not just the guys who found it, but also like everybody in the neighborhood of Syria or Jordan or wherever it is, Arabia. Why would that be so is an interesting question. Because after all, the guys who found it actually did find it. I mean, they did something which nobody else did. If there weren't people like that around, then presumably the Arabs today would still be illiterate and extremely poverty-stricken nomads. There wouldn't be nearly as much trouble as they are now. Okay, so Locke takes it that nature belongs sort of in common to mankind. And if you start out with that kind of assumption, you got a problem. Because Locke does also want to defend private property. He wants to say, yes, we can actually come to own some of that stuff out there. And how do we do it? Well, we do it by something that he called mixing our labor with it, which means, so to say, working on it. Which roughly means, well, doing something with it, something that's of interest to you, and something that involves you in some way or other, all right? And of course, farming is our sort of standard classic example. You dig up the land and you start growing stuff on it. Why do you want it to be yours? Answer, because after all, it takes a while for the crops to grow, and if I don't own the thing between now and when they're harvested, I might as well not bother to start planting the thing in the first place, because after all, the point was to feed me and my family, and if you get it instead the day before I go to harvest it, I've had it. So I have a great interest in having a property right to this. Now the question is that interest enough to justify giving it to you? And the Lockean classic answer is yes, but it's an answer that apparently goes against the grain of the common ownership claim. On this point, I add that the modern fix on this is very simple, because the common ownership claim is actually a ruse or a scam or a myth. It's just not true that mankind in any interesting sense owns everything. All it's true is that they're scattered around the place, and the place is scattered around the place. And until somebody starts doing something with something, why that person should be regarded as any sense the owner of it is highly problematic. Whereas the guy who actually does find it and starts doing something with it, the homesteader, as many theorists now call it, has done something with it. Okay, now the main thing to bear in mind about this is that when somebody makes something his, what he makes his is something that if he has it, then other people don't. I mean, they're excluded by it. We can't all own something at the same time. And in one sense of the word, we can't even two of us own something at the same time. Why not? Well, because the idea of ownership is you can do whatever you want with it. So suppose the two of you can do whatever you want with it and you want different things. Then what? Well, obviously you then have a problem. And either you come up with a system of sort of joint ownership, the two form a partnership of some kind, and then they distribute the decision-making rights between them in some way or other. Or one of you sells out to the other one and he becomes the sole owner. But the point is, ownership is univocal in a way that the common ownership thesis disallows in any interesting sense. Okay, so now, please note that the people who don't like private property on this ground don't like it on the ground that the people who are excluded have borne a cost. And they ask, why should people bear this cost? Now notice that rights inherently have costs. Indeed, I would want to suggest that a right is nothing more than a ground of imposition of duties on other people. And specifically, the duty to keep off, the duty to allow you to do the thing in question and not to attack you in the process. Now that to you is a cost. And when I'm prohibited from doing something, no matter what it is, including killing you, it is nevertheless a cost. It's something I might have wanted to do, that I might have seen as a benefit. And if you have a property right to something, this notionally at least excludes me from making use of that, which is something I might want to do. So of course, that's a cost. Well, it is a cost, but of course, please notice that absolutely all of us bear this cost all the time if we're going to live in a peaceable society where people can get things done. So, roughly speaking, we move to the extremely important general point that property rights are a way of heading off disputes which there would otherwise be no way of settling. If the fact that you got there first and are using the thing now isn't a reason why we should keep off of you, then of course we won't keep off of you, and nobody will keep off of anybody, and we will have what Hobbes calls the war of all against all, and that would be bad for everybody, where everybody is literally pretty much everybody. Unless, perchance, some person was strong enough to defend himself against everybody, something that's highly, highly unlikely, though not logically impossible, certainly. Well, all right, so among all of us normal people who are not Superman or God, property rights are a very, very good device for heading off these disputes. One more little point to make about this, which was wonderfully made by David Hume, by the way, in his classic treatment of the subject, was that after all, if we say, well, look, I mean, some mediocre bloke could have been the first one to stumble upon it. Hume says, right, and that's not a disadvantage of property rights, it's an advantage. Because otherwise, consider that we would have to settle the subject of who's more meritorious, who has more moral virtue or whatever. He's the one who should have the thing, who's going to decide that? Well, of course, my answer is I am, and your answer is you are, etc. And we're back to the state of nature. And that was what it was Hume's brilliant insight to point this out. So this fact that being the first comer is usable for settling points in a nice, definitive way is very, very important. Please note also another thing, and that is this whole idea that we have rights to things comes sort of basically from the evil of war, as Hobbes said, the evil of war. That is to say, a right says you can't do this stuff to those people. You can't take it from them. You can't hit them in the nose. It's their nose, etc. And that would be war. And a right excludes that kind of war. It excludes aggression. It says we confine ourselves to a peaceable way of doing things, the way that are mutually agreed by people. And when we do that, then the way is open for us all to get ahead. And that, by the way, interestingly enough, includes the excluded. We'll get to that some more a little bit later. Okay, now another thing to mention here, and in the context of Kinsella, whom we'll be discussing pretty soon, this is a pretty important point. People who have Locke's kind of view, which is also my kind of view, and Nozick's and lots of other people's kind of view, nowadays known as libertarianism, tend to claim that people are, as it were, self-owners. Now, there are some people, including Stefan Kinsella, who lampoon this, saying, what do you mean we own ourselves? And that's a good question, but luckily it has a good, clear, straightforward answer. If to be the owner of something means to be the person in charge, the person who can use the thing, the person whom other people have to ask before they can use it, then just take the case where what you own is you. So self-ownership then says you may do with yourself what you please, which is equivalent to saying you may do what you please, because whenever you do anything, you do something with yourself or some part of yourself, and it's all, after all, we suppose, yours. So the claim that liberty is, so to speak, based on self-ownership is highly misleading, because self-ownership is just a sort of a way of saying that people ought fundamentally to be at liberty to do what they want, ought to be in control of themselves, ought to be their own bosses, so long as they don't thereby violate the rights of anybody else. Right? Now, this leads me to make a quick note about somebody, a mythical figure I invented called Saint Pareto. I don't know how many of you have heard of Pareto, the original Pareto, who was an Italian sociologist and economist of early 20th century. But it's to Pareto that we owe discussion of notions of what's nowadays called economic efficiency. Economic efficiency is somewhat special. And the basic idea is this. I suppose you've got a bunch of people in some condition or other. Suppose that somebody does something which makes at least one of those people better off and doesn't make anybody worse off. Then Pareto says that the new move is Pareto superior to the old configuration. Changes in society such that some people are better off and nobody's worse off are Pareto approved improvements. Now, we can make this into a moral principle. I suspect that Pareto himself thought of it this way, but it's not clear whether he did or not. However, lots of us do, at least going back to St. Augustine and probably a lot more, Socrates for that matter, who affirmed the do no harm principle. Now, if you take the do no harm principle to say, don't make anybody worse off, don't worsen the situation of other people when you interact with them, and if you make some of them better off, that's fine, but don't do it by making some of the other ones worse off. So you don't rob Peter to pay Paul. All right? That's what I call the gospel according to St. Pareto. It'll be noted that what I call St. Pareto and Kant have a lot in common. Kant also thinks that people have this fundamental right to do as they please as long as they don't interfere with the rights of anybody else. Now, I next point out that if we ask the question, well, why do we own ourselves? The answer is, original acquisition. All right, well, how do we acquire ourselves? The answer is by being ourselves. So you're born, and after a while, some unclear amount of time, you start being aware of things and this and that. And the idea is that when you do, or as you develop enough to be aware even of things like being a self, there you are. Now what you are is you're in possession of yourself. That if you discover that you've got these arms and legs and stuff like that more or less do what you tell them to, they're connected to you in a way that they aren't connected to anybody else, that's the possession of you by yourself. Now, if we convert this into self-ownership, which remember is a moral thing, a normative thing, then we do indeed have the libertarian principle. The point being then that the liberty of the self is a case of original acquisition of rights on the libertarian view. Please note that this view is non-trivial. A lot of people have thought that self-ownership is a trivial idea. They could hardly be more wrong. It is an extremely non-trivial thesis. In fact, it's a wildly radical thesis because it affirms that, for example, governments or gods or neighbors, etc., that there's a line which they are not allowed to cross, no matter how many of them there are, how few there are of you, or what size you are, or how smart you are, or what color you are, etc. So the idea is that this simple fact of being an individual person with a mind who is able to do things is all it takes to have the fundamental right of general liberty. All right, now let's move to making or invention, which brings us closer to the kind of rights we're interested to talk about, namely intellectual rights. Why would making be another good case of original acquisition? Well, look, we can distinguish two cases of making. In one of them, you pick up some stuff from nature and you make something out of it. And what you do with it is to improve it in some way or other. E.g., you cultivate it and start growing vegetables on it or whatever. And the other way is, well, you start working on some material or other which turns out to be somebody else's. And you nevertheless put your labor on it and do something with it. Now there'd be a problem because after all, the original thing belongs to somebody else and you're violating his rights by using it. On the other hand, you've done a lot of stuff with it, we will suppose, you put a lot of your labor into it. And if the other guy had said, well, give it back because after all it's mine, and you say, yeah, right, but wait a minute. The state that it was in when I got it from you was essentially nowhere by comparison with now. For example, I have just carved the piano out of it. We have a problem. We'll get to more of that sort of kind of thing later in the paper, but just to know that there could be a problem of that kind. But let's take the case where there isn't a problem of that kind, and you ask, why do we come to own, why should we regard it as coming to own what we, in Locke's words, mix our labor with? His answer was because, after all, the labor is yours. The libertarian principle says that. You own yourself, therefore you own your labor. Now he wanted to say, and therefore you own whatever you mix it with. But of course, as the point I've just made clarifies, some of the things you mix it with there might be hooks on, and it might not be so straightforward. But take the case where it's a thing that didn't have that kind of hook on it. Well, as I say, Locke thought it was the common ownership of mankind, and so when you make something out of it, you nevertheless have a bill to pay to mankind in general. There are still people today who hold that view. I'm not one of them, because I think it's crazy to think that mankind owns anything, and crazy to think that anybody who hasn't done anything at all, or even somebody else done it and given it to him, has any ground whatever for being regarded as the owner of something, etc. So I think that the idea of communal ownership from time initial is complete nonsense and won't really take it seriously in future. Therefore, since what we mix our labor with has no moral status whatsoever, whereas you do, and what you do does, then I want to say the things that you make are also yours. There's every good reason for regarding them as yours rather than somebody else's. Every good reason for excluding others from doing anything with it without your consent. Now, next, a point which will also loom a bit larger later. I want to talk about goods and services for a moment. It's customary in economic discourse to distinguish goods and services. Goods would be, for example, hamburgers. Services, for example, would be performing a piano recital for somebody. And there is, of course, a distinction of that sort, but they have something in common. And for our purposes, what's in common is what really matters here. What they have in common is this. In an economic context, a good is so-called only in the context of exchange. A good has an economic value, an economic price, only because somebody is willing to give it to somebody else, provided the other person do something, pay for it in some way, for example. And so the person who does the selling is in fact doing a service to the person who buys. Selling is the service, and that's what you actually pay for. When you say that I bought the car, you don't mean that you paid the car some money for something. You mean that you paid the dealer or the previous owner for something, and what you paid him for is letting you have the car. That is to say, undoing his own previous hold on the car. He previously had the legal right to exclude you, and what you do by your payment is to get him to lay down that right, in fact, to transfer it over to you, and that, of course, is a service. A lot of the services that we pay for are precisely that, services in allowing other people to use certain goods, making it theirs, but nevertheless, that's what they do, and that's where the money figures in. That's why there is actually exchange. Okay, now let's move to intellectual property. And the first fundamental thing to do here, and something I'm going to accuse Stephan Kinsella and a lot of other people of not paying enough attention to, is to distinguish between two kinds of ideas or intellectual entities, as we might call them. So let me distinguish between ideas in Plato's heaven, as we put it back in our Philosophy 100 days, and ideas in the sense in which they are in somebody's mind, ideas in our heads. Now there's another distinction, which some people think is the same distinction, and that's the distinction between universals and particulars. And it is pretty close to the same, but not quite. Now, what's a universal? Well, consider the number 17, right? Well, we have, like 17 chairs over here, and 17 more chairs over there, and 17 trees in some area out there, et cetera, et cetera, et cetera. There are 17s all over the place. What they have in common is being 17. People like Frege and Russell and Whitehead and whatnot wrestled with the proper formulation of this, but roughly speaking, 17 is what all 17-membered classes have in common. Now, the 17-membered sets of entities like those chairs are particulars. Each of them, there's one and only one of those. Well, there's one and only one collection of 17 of those chairs. But the chairs are themselves actually particulars. But the idea of 17 isn't particular, it's in common to an indefinite number of different things. Plato talked as though 17 and all the other ideas there are were actually, in some mysterious sense of the word, quote, things, universals. And when we talk about Plato's heaven, well, that's a sort of notional or mythical way of talking about universals. I take it will be completely obvious that you can't own a universal. It doesn't really make any sense to say that you have a relation to a universal, anything like the relation you have to your car or yourself or whatever. They just aren't that sort of thing. Particulars, on the other hand, are that sort of thing. Now, about particulars, we can make another distinction, which may loom rather importantly too in this discussion, and that's the distinction between concrete and abstract. It's a little harder to clarify these with any sort of straightforward definition, but roughly concrete things exist in space and time, and they have lots and lots of properties. I mean, here's a chair. Well, it's got color, and it's got shape, and it's got... Now, consider the color of this chair. Now, I don't mean the color of this chair in the sense of black. I mean the bit of black that is spread out over the seat of that chair, as distinct from the bit of black that's in that one or that one or that one, right? Now, it takes, some notional exercise to get a grip on this, but nevertheless, I think you see the idea. That is, the distinction of abstract and concrete is not the same as the distinction between universal and particular. There can, in fact, be abstract particulars. And if we take our 17-member set of chairs over here, then the 17-ness of this 17 chairs is something that they've got. So 17 is instantiated by that particular collection of chairs, but it's still abstract. Ideas in our heads are like that. They are particular, they're not universals. When I do arithmetic, the idea of 17 occurs to me at a certain time and then recurs at other times and so forth. And what's in my head, what's going on in my mind, is a particular. It's going on in my mind, not your mind. And if it is going on both in my mind and your mind, what's going on in your mind is nevertheless a distinct entity from what's going on in my mind. If lightning strikes you dead 2 seconds from now, the idea that you were entertaining suddenly ceases to be entertained by you since you don't exist anymore. Whereas the very similar idea that I'm entertaining, suppose we're thinking about the same thing, isn't dead because here I still am and I'm still thinking about it. Okay? So ideas in heads on the one hand and ideas as universal in, so to speak, Plato's heaven and another thing. And please note that quite obviously I can, and I would want to say do, own my own ideas. I own them in the following straightforward sense, the same sense that I own anything else. Namely, if I want to do something with it, I do it. And if you want to do something with my idea in here, you have to ask. Now, it might be pretty difficult. But, for example, maybe you can rewire my brain so that I'm thinking something I don't want to think. That would be an invasion of my mind, and it's something that you're not allowed to do according to the Schedule of General Fundamental Libertarian Rights. Okay, so now let's get to the subject of intellectual property. So we can't sell Platonic ideas. Nobody can own the number 17 or the fact that 2 plus 2 equals 4. However, we can sell our own ideas. That is to say, I could have an idea which you don't have and which you'd like to have, and which I'm in a position to give you by, for example, telling it to you. The language is a wonderful device for people, enabling people to communicate as we say their ideas to each other. So I can get an idea into your head from mine by a linguistic act, for example, and so forth. Now, please note that when it comes to Platonic forms, there's no such thing as scarcity. People have sometimes sort of wrestled with this and wondered if there could be, if the stock of ideas in Plato, in the Platonic sense, might be limited. I'm inclined to think that that is nonsense, and I suspect you can prove that mathematically, and I don't want to try it, partly because I don't know much about mathematics, partly because who cares? It's obvious that there are indefinite, well, an infinite number of, at least infinite number of Platonic forms. Take, for example, the whole set of finite numbers, which is infinite, and there you go. All right, scarcity doesn't apply to Platonic forms. It does apply to ideas in heads. Every now and then, some head has an idea that nobody else has at all. And what's more, an idea that's better than prevailing ideas about the thing in question. And when that's the case, he might be in a position to offer to transfer it to somebody, or rather to impart it to somebody else for a price. He might. There's nothing impossible about this. As a matter of fact, it happens quite frequently, e.g. when people become other people's teachers. Now, of course, a thing to notice is that when the idea, when I get the idea, as it were, from my head into yours, the word from is misleading because it doesn't leave my head. That's the funny thing about ideas. I can get my idea into your head without losing it myself. That's the sense in which these particular ideas aren't scarce in the same way that, for example, cars are. If I give you my car, then I don't have it anymore. If I give you my idea, I do still have it. And that's the basis of Stephan Kinsella's problems with intellectual property. So I now want to turn to his discussion full tilt, as it were. How am I doing on time, Stephen?
4:50. So,
I've got how much?
say till 5, 10 minutes? You
Let
want-
me
you
run
want
away
to
with
do that?
15.
Fine.
Okay. Okay, Stephen Kinsella comes along. And he says, look guys, ideas, intellectual so-called property isn't scarce, and scarcity is a necessary condition for ownership. If it isn't scarce, then you can't exclude. David Hume, long ago, in a wonderful passage in the Inquiry into the Principles of Morals, pointed out that if we all lived in a sort of embarrassment of riches, anything you wanted was automatically there. You have but to stretch forth your hand, and if somebody else takes it, well, you have but to stretch your hand and give another one. And if that was the case, if there was absolutely no scarcity, there would be no need for justice at all, says he. Now, I mean, at least there would certainly be no need for property rights kind of justice. That's quite obvious. So he's certainly right to say that we've got to have some sort of scarcity in order to have property. But, as I've just pointed out, once we distinguish between Platonic ideas and ideas in the mind, we do have scarcity. As I say, every now and then somebody comes up with an idea which nobody else has. And then what? Well, it is now scarce in the sense that the person would be in a position to supply it to somebody else and do that other person a service when he does so, even though he still got it in his own head afterward. Okay, Kinsella then says, well, who argues in favor of property? What kind of arguments are there in favor of property anyway? And proceeding like too many philosophers, he makes a distinction, which, as it turns out, is not sufficient for the purpose. He distinguishes two kinds of arguments, what he calls utilitarian arguments and natural rights arguments. For the benefit of anybody, are there any philosophy majors out there? Or something like that? There's one anyway, all right. Many philosophy books these days, almost all books in moral philosophy these days, make a distinction between something that they call deontology on the one hand and consequentialism on the other, as if those were lead to fundamental different kinds of moral theory. I'll explain in a moment why that's complete nonsense. But we'll start with utilitarianism and natural rights. Now, Kinsella says about utilitarianism, he advances two interesting objections, and they're both fairly familiar in the trade. Number one, and easily the most important one in the business, is this. Now, first a note about what utilitarianism is. Utilitarianism is the following thesis. Background. We're supposed to be able to measure something called utility. Utility is, roughly speaking, happiness or satisfaction, roughly, right? And if you think you can measure that, and it's easy, all right, give the world. But anyway, but the idea is, okay, well, I mean, obviously it varies in amounts in some sense or other, and his idea is, okay, a difference of person is irrelevant here. What matters is just the happiness. And what we ought to do is increase the amount of happiness in the world as much as possible. Now, this is net happiness. So if we can increase happiness over here by the number 10, although it decreases the happiness of this person over here by 5, we've got a net gain of 5. And that might be the best we can do, and if so, we should do it. So says utilitarianism, at least in the standard characterization of it. Obviously, utilitarianism, as so conceived, might countenance what has come to be called in the trade redistribution. Redistributive ethics is, for example, let's take from the rich and give it to the poor. The particular utilitarian reason for doing this would be, it's also been spelled out by Hume, who next to Plato about everything, might be that after all, a unit of, say, $1 in the hands of the poor is worth more than $1 in the hands of the rich. Right? How much will a rich man do to earn $1 more? Practically nothing. How much will a poor man do? Quite a lot. Or make it $1,000 to allow for inflation. And you see the point. And utilitarianism says, well, in that case, we ought to redistribute. All right? those of us who believe in property rights, we libertarians say, nope, can't do that. This violates the gospel according to St. Pareto. You don't take from the rich in order to give to the poor. You don't take from anybody in order to give to anybody else. What you do is you negotiate a deal. If the poor need something and you'd like them to have it, well, good-hearted people give it to them. Or they try to find some way to put them to work or whatever. But what they don't do is steal from the rich or anybody in order to supply them with it. That would be redistribution. Now, we won't discuss utilitarianism here in this basic way. We will assume that Kinsella's objection is a good one, and that we don't want to be utilitarians in this sense of the word. I might note, however, that it's not obvious that this has any effect whatever on the discussion of intellectual property rights. Because recognizing intellectual property rights doesn't redistribute anything. Not yet, anyway. Okay, objection number 2. If you're going to defend property rights on utilitarian grounds, what you have to do is say, well, giving people property rights has the effect of increasing the total general level of happiness or whatever. Now, that is not a stupid thing to suggest, to put it mildly. It's at least pretty obvious, and we will take this to be sort of axiomatically obvious, that when you make some interesting good thing that people are willing to buy, a whole lot of people are willing to pay for it, cars, for example, or iPods, etc., then you have improved the happiness and well-being of a whole lot of people. And you haven't, when you do this, done it at the expense of anybody else. Therefore, you've acted in accordance with the gospel according to St. Pareto, and therefore that's a good thing. Utilitarianism would agree that it's a good thing, of course, because utilitarianism says the more the better when it comes to happiness. And again, it doesn't offend against the gospel according to St. Pareto. And the question would only be, do intellectual property rights actually increase the size of the pie? That is guaranteeing somebody, for example, a monopoly on the production of this gizmo that he's just thought of the idea of, a way of improving the well-being of mankind in general? Will it cause more of this stuff to be produced than there otherwise would be? That's what he means by increasing the size of the pie. To which Kinsella says that there is, quote, no evidence, unquote, that it does. Now, the claim that there's no evidence that it does seems to me to be way, way out on a limb. I would have thought, if anything, it's pretty nearly obvious that saying to somebody, go ahead, get it into production, and we will let you make it. Nobody else can make it for a while anyway, or something like that. I would guess that being in a position to say that to somebody, it very likely does increase and probably greatly increase the likelihood that these good things will be made, at least by beings such as us, namely fairly self-interested people. I'll leave out my little sermon about consequentialism and deontology in the interest of time. Now, what about natural rights? Kinsella says, well, according to the natural rights, we own all of our ideas just because they're ours. And he thinks that's wrong. And at this point, I want to say 2 things. Firstly, of course, we possess our ideas just because they're ours, because by definition, what it means is to be yours, agree to possess them in the sense of possession. What if we say, well, but not only do you possess them, but you have a right to those ideas? Well, all it means is that nobody can attack you with a view to, as it were, trying to take those ideas away from you. Nobody can damage you, can threaten even to damage you in the respect in which you have those ideas in whatever way that you can do this. Why is that a problem? Well, Kinsella thinks that if we did really take this view seriously, that would be the death of all civilized intellectual exchange and all commerce. Because think of all the ideas there are, and suppose that in order to use any idea that anybody else has already had, we got from another group, you got to pay a price for it, we would all be weighed under with this kind of debts, right? Is this a good point? Well, I think the answer to this, interestingly enough, is no. And I think it's no because of another thing, which is that Kinsella thinks that the only kind of prices there are economic prices paid for in currency, like dollars and that kind of thing. Well, no. I mean, suppose you're having a seminar on something, and you've got a bunch of people discussing things, and you've got people coming up with interesting new ideas, and the whole class is there listening, and they get all this stuff for free. They don't pay for it. How is the person who volunteered the idea, how is he rewarded for this? Well, partly by other people recognizing it and saying, hey, what a good idea. Partly by them saying, yeah, but wait a minute, maybe we can improve on it, et cetera. I mean, the give and take. This is a bunch of exchange, and it is mutually beneficial, and no money is involved. So, firstly, we shouldn't think that thinking of ideas in our minds as literally our property in the sense of things that we have the right to have, we shouldn't think that that involves everybody all the time getting into monetary transactions with transaction costs and all that kind of stuff. It's not true. Actually, only a very relatively few of our ideas would qualify for this, and those would be which? Well, they would be the ones who were good enough and original enough so that other people would be willing to pay for them because they're scarce in the relevant sense in which Kinsella says that economics requires scarcity. All right? He also says that intellectual property would have a horrible problem with boundaries, that when you have concrete objects like land, well, I mean, we can tell whose is whose because here it is, yours over there, and here's yours over there. Of course, as anybody in the business knows, that you have to draw a line between these two plots, and the line is not always so obvious where it should be drawn, et cetera, et cetera. And it's pretty obvious that just because you're talking about material entities like land, it doesn't follow that you have clear definition. You usually don't. In fact, I think it's possible literally to prove that you can never have absolute definition of any concrete ownable object. To say exactly where that object ends and the next one begins is actually going to be impossible. And we don't, and luckily we don't need to. I mean, we're close enough, there's close enough. Here's my car, there's your car. Pretty obvious which is which for most purposes. So, yes, it's true that material objects often are reasonably well defined and have reasonably natural borders, but also true that sometimes they're disputable and that's important. Well, what about ideas? Well, same thing. Ideas have definition. That's their boundaries, their borders. Where does Einstein's theory of relativity leave off and some other theory begin? Well, and you need do some work, intellectual work to see, but nevertheless, they're clearly different things. Maxwell's equations are different from Einstein's, they're different from, et cetera, et cetera. So it is not true that intellectual property would have an insoluble problem about borders, which makes them incapable of figuring in any sort of commercial or other transactions. Now that seems wrong too. Now Kinsella wants to say that natural right makes creation sufficient for ownership, and doesn't have scarcity, but we want to ask, what about necessity? I mean, he says that the natural rights theorist, this notional figure, says that all ideas are yours by virtue of just your putting in the intellectual labor that creates them. And Kinsella wants to say that that's neither necessary nor sufficient for having economic value. I want to say that in fact it is both necessary and sufficient. It's just that when you own an idea which a zillion other people own too, it isn't worth anything. You can't sell it for anything because they've already got it. Or they can get it at a trivial cost, namely none, from their neighbor if they can't get it from you. If you want to be so pissy as to not tell them something obvious, then all right, they'll get it from the next guy, etc. Trivial information is still information. It's still owned by the person who has it, but for the most part, it's information we're perfectly willing to give away, or at least trade for absolutely minimal something from the other guy and not money. So, a problem that we don't have time to go into, obviously, is, so we say you've got rights to these things, but please note that when you have a system of patents and copyrights, What those do is to give exclusionary rights in a very important sense because they exclude people who might very well have been able to think up the same thing themselves. And now that's where the problems set in. If I give you a patent on something, which somebody else, maybe 2,000 miles away, has also invented, what gives you the right to exclusive manufacture of the product that he makes and not him? Since, after all, he didn't get it from you, he didn't steal it. And theft is the only thing that we're worried about here with these rights. That is, the right to a certain thing is the right of the people not steal it or damage it, etc., not use it without their consent. The same holds of ideas. But when somebody else picks up the same idea that you had, perhaps somewhat later, we now have a problem, because if you're allowed to make the thing and forbid him from making it, then he really is losing something, because after all, he thought of something which would be a source of value. This way of this idea for the better mousetrap or whatever, and you're now excluding him from having it, which means you're actually reducing his utility, thus violating Pareto. So I agree with Kinsella about this. That is to say, it isn't clear that there's a case for giving monopolies on something which the ground for which is going to occur in somebody else, quite possibly, and it excludes him from the benefits of it. I mean, there's something wrong and unfair about that. Okay, well, we got quit pretty soon, but so far what I'm saying is this: it looks as though in the following case, namely, A has the idea, it is valuable, it maybe costs A a lot to produce the idea. Drug companies are your favorite example here. They spend millions and millions of dollars coming up with a new drug, a lot of which, of course, is spent trying to meet the FDA's requirements, but nevertheless, they invest a whole lot of labor into it. They produce the drug, and then once it's produced, the next guy down the road has merely to buy one sample of yours, analyze it, and he can reproduce it just like that. He can copy it. Copyright is to prevent people from doing that. It's not obvious that we shouldn't be able to prevent people from stealing other people's stuff in that sense. It seems to me that there is a basis for copyright, which Kinsella's arguments do not defeat. So he's right that ideas are intrinsically transmissible, and they're not in the relevant sense. Relevant sense scarce, in the sense that if you have it, the other guy doesn't, and vice versa. Nevertheless, they're scarce in the sense that some people have them at times and other people don't, and that when that's the case, they're worth something to the other people who would be willing to pay for them. And it seems to me that he hasn't shown that that's not the case. He does say all that the rules of liberty will allow you is contract, which is approximately true, but not quite, because two people can only contract for something when they both own whatever it is that they're giving to each other. And what do we own in this case? Answer: our own lives and liberties. That's the sort of basic background. So if you violate, I mean, if I make a contract with B to reproduce my idea, and you come along and you take it from B rather than from me, you're still violating my right, is what I want to claim. Because you didn't pick it up, you stole it from somebody who had it only on the basis of a contract from me that forbade him to give it to this other guy without consideration. So, in short, I can't see that Kinsella has shown that there's no room for copyright, but I think he has shown, firstly, that it's not very obvious how beneficial copyright is. I think that's true. You have to show that if we didn't have copyrights, we wouldn't have all the stuff that we do. And it's very hard to know whether that's true or not. How many things would have been invented by people who didn't mind not being an exclusive producer of them? Who knows? In the end, as I put it at the end of the paper as it is, there probably are some people out there who actually believe the communist slogan, from each according to his ability, to each according to his need. Those people are going to think up a lot of things and generously giving them away to free to other people, and we certainly can't prevent them from doing that. That's perfectly fair. If they want to do that, that's their idea. That's why they get to do it. Would it be better if everybody were like that? I don't know. But everybody isn't like that, and we should be busy protecting the people who are, and who do things for their plain old self-interested reasons that business